Welcome, friends, colleagues, alumni, students, to the second in the MonaLaw Masterclass Series. I'm the Deputy Dean for Graduate Studies and Research at the Faculty of Law, the UWI Mona. I'm Tracy Robinson, and a longtime teacher. These masterclasses, which we started this semester, are simply our classroom spacing out, and in an area of graduate teaching on a topic of importance to the wider community we serve. It is a virtual community classroom. The first two master classes, this one and the one before, have been in the area of corporate and commercial law, but we expect to also conduct master classes in public law soon as well. This classroom is in company law and includes nearly 200 students who are undergraduates, but as important, it also incorporates our graduate students who are undertaking the LLM in corporate and commercial law. And that LLM includes teaching in corporate insolvency, company law theory, corporate governance, amongst others. And it also includes a number of students who are specially admitted to do one of the LLM courses. We also have in our classroom today graduate research students who are working on MPhils and PhDs in law. Our graduate research students are looking at topics such as financial crimes like scamming, money laundering, regulation of the cyber world, surrogacy, corporate taxation, family property, financial regulation, tribunals dealing with access to information, human rights and investments in bauxite, among other topics. Many of us know the University of the West Indies for its 50 years of undergraduate education, the LLB degree, and the master classes really remind us, particularly those of us who are well past the LLB stage, that UWI has a very strong commitment to graduate legal education as well. And its LLMs in corporate and commercial law, public law, and intellectual property are important offerings here as well. This year, we admitted about 20 Caribbean professionals to do one graduate level course with us rather than the entire LLM. You are sole practitioners, law firm seniors and juniors in St. Lucia, Trinidad and Tobago, Antigua, Jamaica, state councils, in the Attorney General's chambers in Guyana, chartered accountants in multinational accountancy firms in Trinidad and Tobago, amongst others. We are in the classroom today of corporate law scholar Suzanne Goldson. She conceptualized and began master classes at UWI a few years ago, and you may know she has a new book out on the Jamaica Companies Act, which is in soft copy now and soon in hard copy. She'll be joined by Dr. Celia Blake, who teaches insolvency law at the graduate level, and she led the first masterclass in September of this year. There is no better person to teach in Suzanne's classroom today than the premier corporate litigator, the Honorable Michael Hylton. He brings to the classroom today not only his legendary intellect and his unparalleled gift of making sense of law with simplicity and clarity, but nearly 5 decades of litigating precisely the matters before the highest courts that are in discussion today. Generations of lawyers have been schooled by him in law firms, in court, in the classroom. Our goal at MonaLaw is to teach and serve all, and he, more than anyone I know, operates with deep generosity to all in his profession. Indeed, many of you are here today because you're accustomed to him. You're accustomed to his guidance, his thoughts, his framing of legal issues, his teaching, maybe even on similar topics. Still, with each encounter with Michael Hylton, the consummate teacher, we learn anew, especially as the law evolves, and as with good teachers, we start looking forward to the next possible engagement, to the ways in which he's going to help us in the future to shape our thought and our understanding. As the Faculty of Law, which was established in 1970 this year, celebrates 50 years, we can't be but more pleased than to sit at the feet of one of its best graduates, a man who started his stellar journey in law here at the Faculty of Law at Mona just a year after its inception in 1971. And a special welcome to Michael Hylton and to all of you. Now over to you, graduate and undergraduate corporate law lecturer, Suzanne Goldson.
Thank you so much, Tracy. Good morning. Good morning to all my colleagues across the region. Good morning to my students. A special welcome to the students of company law at St. Augustine and to my colleague, John Jeremy. of way back when. Welcome. And of course, welcome to all of those from across everywhere, because I know there are some people joining us also from Canada and other Commonwealth territories. So thank you for joining us. And I am very, very pleased to have Mike Hylton, the Honorable B. St. Michael Hylton, with us again to take us through this journey on company law. It is with gratitude that I welcome him yet again. I just wanted to run through quickly how we will proceed this morning. We will, after my introductory remarks, I will ask Mike to make his presentation. That will be approximately 45 minutes to an hour. And then we will have about a half an hour for question and answer. So we will have a range of questions from YouTube. So I'd like to welcome my YouTube participants as well. And you can enter your questions on the chat. And of course, from the class who are on Zoom. So welcome again. And I just wanted to put this class in context. Over 30 years ago, when I was doing company law, I'm embarrassed to say, well, maybe not. It's a good thing. You know, we were taught that the bedrock of company law is a separate legal entity doctrine. And of course it is, from which everything else flows in company law. And I was taught Salomon and Salomon, and then I was taught these neat little compartments where the doctrine would either be ignored or not apply, or we would lift the courts would lift the veil. And they were all in these compartments, and we'd all spout it back beautifully. And there was some certainty, although we had a sense that things weren't going as planned, because sometimes the courts would go off and lift the veil when we didn't think it should, and that formed part of our argument. Fast forward 2020, I won't even go that far, maybe 10 years ago. All of a sudden, I see this resurgence of a desire to stick with the separate legal entity doctrine and not so readily lift the veil. And this has come about because the corporate form has been used for so many other reasons, for estate planning, for family law issues and so on. It touches and concerns so many other areas of law. And with this renewed desire to stick with the doctrine has come a lot of desire also to circumvent the doctrine by not lifting the veil. And so we see where the law has evolved using tort law, using private international law, using, human rights law, all these areas of law, trust law, as I mentioned earlier. And I just wanted to pause for a second and welcome Professor Poonam Puri from Osgoode Hall Law School, who has done tremendous work in this area, focusing mainly on the corporate governance aspect of this, where you have parent and subsidiary multinationals, where the corporate form could be taken advantage of or lends itself to being taken advantage of. And so we will find today then that as Mike takes us on this journey, we will find that there are ways in which the courts have tried to maneuver to pay allegiance to the separate legal entity doctrine while legitimately lifting the veil or finding other creative means to avoid lifting the veil. And that is very exciting to me. Every year that Mike has come to speak to our class, something changes. There's a new case law, not just in the Commonwealth, but in the Caribbean or even in Jamaica. In our small island, there's a case that says, should we follow this? Should we follow that? And so I look forward to what Mike has to share with us this morning, and I'm sure this will enlighten you. And as he takes us on this journey, bear in mind all the other areas of law which it touches and concerns. And that's a shout out to Tracy, say that, yes, people are not accustomed to seeing you in this forum, but it touches and concerns family law too, and human rights law. So we look forward to that discussion. And of course, feel free when we come to the end of the presentation or during the presentation to type in your questions. Thanks again. Thank you, Mike, for being here. We look forward to the presentation. Over to you, Mike.
Good morning. Thank you, Susan, Tracy. Good morning, friends and colleagues across the region. Topic today, as you are well aware, relates to legal identity, what has been called the practice of lifting the corporate. As Susan mentioned, this has in many ways been and continues to be a journey. And that journey started in England. There was, in 1892, in England who had a quite successful practice. He incorporated a company. The company had over 20,000 shares. He held 20,000 shares and there were 6 shares. He transferred the business to the company. And of course, since he had just started trading and had no assets, the purchase, he took the company's assets. The company continued on the business very much the same way he had done so for years. The change was largely to the customers of the company. In less than a year, the company became insolvent and unsecured liquidated. Later, the merchant claimed in the claimed the remaining assets in priority. The liquidator argued that the was a set of essentials. He succeeded in trial, the liquidator did, and in the Court of Appeal. But the appeal to the House of Lords allowed his appeal. Of course, was Salomon and Salomon. And the House of Lords had been duly incorporated. It was not a mere alias. In those circumstances, Mr. Salomon should rely on separate legal and enforcement. Susan is the bedrock principle and has been followed for decades as basis for modern company law. Even in stark such as and his company showed. Others took the view that is a problem. And the reason for that is that that fairly simple arrangement that Mr. Salomon had has been overtaken. Structures, as Tracy noted, arrangements being a variety of reasons. And persons, separate companies and groups of a variety of reasons. Some have to do with tax efficiency. Some seek to make the business more efficient, limited. Often the purpose is done by various including lawyers in our region, incorporate their businesses. But there's also the concealment cases. Those cases where the corporate entity is to conceal assets to, and I use a full ownership advisedly, Susan mentioned these cases cover a variety of areas, so there are family issues, to conceal it from the world at large. And then finally, the concealment is sometimes because of the source of the assets. Sometimes assets obtained as a result of illegal activity, and that is the reason for the concealment. But sometimes. The result of all of this is that the courts have reacted by finding a way to look behind the corporate structures, to get to a result that appeared to be just in the circumstances and avoid, for example, being used as vehicles for fraud. This is the discussion today. I will use those two words interchangeably. It is often said that the first and most famous of the cases in which the courts pierced the corporate veil was Guilford. Now, Guilford is a case where, involving a contract of employment, the plaintiff company assembled and sold motor cars. Edward Horn was its managing director for about 2 years under a contract that restrained him from starting a competing business, and it said either solely or as agent for anyone else. Of course, the reason why the case came about is because he left the company and started a competing business. Now, the case has a lot of similarities to Salomon because first he did the business in his own name, then he formed a company which took over the business. JM were the initials of his wife, Jessie May. Mr. Horn was not an officer or employee of the company. Only officers and employees, only shareholders and directors were his wife and an employee. But the court found that his wife took no meaningful part in running the business. Like Mr. Salomon, the change was largely invisible to customers. They continued to deal with Mr. Horn in the same way that they had done previously. In this case, however, the Court of Appeal held that it could grant an injunction against the company. The company was, of course, not a party to the contract with Guilford, had no restrictions placed on it by that contract. But the Court of Appeal held an injunction could be granted against the company. And in doing so, they used a phrase that came to be used in many other cases. The company was a device. It was to enable him, under what was a sham, to carry out the business. Now, they looked to the provision in the contract, which said Mr. Horn could not compete either as principal or agent. And so the Court of Appeal said it didn't matter whether the business belonged to him or to the company, since he was the one actually carrying it on. I found it interesting that none of the 3 judges in Guilford even mentioned Salomon. And that's interesting because Salomon was a very famous and celebrated case at the time, and this is only 1933. They didn't use the phrase pierce the corporate veil, made no mention of Salomon. In the years that followed, the courts have gone on to do the same thing, but in very different circumstances. And there's a case that many people have not heard about, but which is very important, for a particular reason. And there are a number of cases called Ria Company, of course, but this one in 1985 in particular involved the ownership of assets. And this is a gentleman who had a network of companies to which he transferred his personal assets. And the issue was whether a claimant could obtain a freezing order against the companies in relation to a claim that they had against the person. The Court of Appeal held that that injunction, that freezing order, would be granted. But the reason why this case is important is not so much the facts or the actual finding, but a passage in the judgments of Lord Justice Cumming, where he said that the court will use its powers to pierce the corporate veil if it is necessary to achieve justice, irrespective of the legal efficacy, etc. And what that judgment and that phrase did was it created for the first time a kind of a definition of, or an indication of when the court will pierce the veil. Now, obviously, this is very vague, and this would give no comfort, especially to commercial lawyers, to be told it will be done when it is necessary to achieve justice. But it was a phrase used in that case as their basis for the decision. Now, I did some research in the Bahamas a couple of years ago. Shout out to 242. And I found that in just a decade following Ria Company, there are a number of cases where the courts in that jurisdiction applied that case, referred to just that passage, lifted the corporate veil on the basis of the statement in that judgment about it being necessary to achieve justice. And the Bahamas is not unusual in this respect. That same thing happened in other jurisdictions. It happened in Trinidad, it happened in Jamaica, in other jurisdictions where courts applied that passage, lifted the veil on the basis of this seems to be an appropriate case to achieve justice. We do so. Now, the Jamaican courts have had other cases where they said that in these circumstances, it was appropriate to lift the veil. And they had other reasons than just simply saying this was a more appropriate way to achieve justice. To comment on one of those cases, Don Juan Crawford was one of the many cases, many appeals to the Privy Council arising from the regulatory intervention in Jamaica's financial sector during the 1990s. Mr. Crawford was the chief executive officer of a bank, and the bank owned a very valuable property. The bank transferred the property to a company called Regardless, ironic name, that was owned by Mr. Crawford, his wife, and his mother. And the court held that he was in breach of his fiduciary duties to the bank because of information he had as to the property's value, which he did not share with the board. But the real issue of the case was whether the bank, under new management, could claim against the company, claim against Regardless to recover the property. And Regardless's position was that it had no fiduciary duty, it breached nothing, and the bank could have a claim against Mr. Crawford, but not against the company. That claim, that position by Regardless and by Mr. Crawford failed in the Court of Appeal, who held that you can't view that company as a separate legal entity in the circumstances of the case, because it was just a vehicle. It was a vehicle and a nominee of Mr. Crawford, and we shouldn't treat it as a separate legal entity, and the claimant should have a claim against it. Regardless, and Mr. Crawford appealed to the Privy Council. Now, in the Privy Council, Lord Walker, who delivered the opinion of the board, spent some time on the relationship between the entities and their principals, and then concluded that the company was a sham, it was a device, it was a mask. And that was the basis on which they held this was appropriate, were appropriate circumstances to lift the corporate veil and to allow a claim against the company for the recovery of the property. Then there have been perhaps more creative ways. There's been the principle and the theory of the single economic unit, which in a number of cases, the courts have said a group of companies or a company and its principal can be treated as a single economic unit. And what's interesting about this is that phrase has been used, not a single legal unit, because the courts accept. Nobody has ever challenged the correctness of Salomon. The courts accept that they are separate legal units, but they say we can treat them as a single economic unit. DHN Food Distributors is the first case in which this was done. And interestingly, in that case, it is the third party who was seeking to assert separate legal corporate identity, not the principals, not the company. What happened in that case is that there were three companies. The one company carried on business, and it had two subsidiaries. One subsidiary owned the property on which the business was carried out, and the other subsidiary owned the vehicles used in the business. The local authority compulsorily acquired the property, and the issue was how would the compensation be calculated. The authority argued that these are three separate companies, and the company which acquired the property suffered no real loss. The company which owned the property, its only loss was the value of the property, not the business. It did not carry on the business, and the parent company couldn't claim any loss because it was merely a licensee. It didn't have a lease, and the acquisition of the property from its subsidiary caused it no loss, save for, of course, the value of the property itself, which the subsidiary lost. This ended up in the Court of Appeal, and a court led by Lord Denning treated the companies as a partnership. That they were a group, and they considered the separate legal personality as a technical point. There was a phrase that was used in the case by Lord Justice Goff, the realities of the situation. And that's a phrase that became more popular than that other phrase in the interest of justice. The realities of the situation were something other than the legalities. And the reality of the situation, apparently, was that this was a partnership. These were really one unit. And they therefore allowed the companies to claim that they had suffered a loss of the business in the calculation of the compensation to be paid by the local authority. A few years later, the same court, English Court of Appeal, returned to this issue in amalgamated. Very different type of case, same result. So this is a case with a bank loan. The plaintiff and the bank agreed on a loan, and it was agreed that the loan would be made to the plaintiff's subsidiary company, a company called ANPP. This subsidiary was based in the Bahamas, and because of the exchange control restrictions in that country at the time, the bank created a subsidiary also based in the Bahamas, lent the money to its subsidiary, the bank subsidiary, and the loan was therefore between two Bahamian entities, the bank subsidiary to the plaintiff subsidiary. However, the security for the loan was a guarantee from the plaintiff to the bank. Money lent to the plaintiff subsidiary by the bank subsidiary, guarantee from plaintiff to the bank. Needless to say, there's a default. The bank tried to enforce the guarantee. The liquidator of the plaintiff argued that the guarantee was not enforceable because it was to the bank, and the bank didn't lend the money to the company. The money was lent by a subsidiary, two separate entities. The court held you should treat them as one, the bank and its subsidiary, as a single economic unit. And so treat the loans as if they were made by the bank and repayable to the bank. And the bank allowed the enforcement of the guarantee by creating that link and by creating and recognizing a single economic unit theory applied. And this was also Lord Denning. He talked about the realities of company life. Wholly owned subsidiary does exactly what the parent tells it to do. The case was a little stronger, perhaps, than just that, because as they pointed out, the company, the subsidiary, had no business. It just was a pass-through from the parent. But you'll note that there was no issue of any improper purpose. There's no issue of any lack of due corporate structure. The court just felt the realities of company life was that this was not really a separate entity. Now, it's perhaps not surprising that these cases many of these cases were led by Lord Denning. He was a critic of the Salomon principle long before these cases. And this is a quotation from the 60s, before he even got to the Court of Appeal, where he said the doctrine in Salomon and Salomon had to be watched carefully. And he said it was, in fact, the court can see behind this veil, can and should draw it aside to see what really lies behind. Now, an approach which goes beyond what many of the other cases say, not just a matter of if justice requires it, but this principle in Salomon and Salomon is something that was a source of concern, a source of suspicion, and one should look behind it and see what really is the circumstance. Now, lots of people welcome these decisions and welcome this circumvention of Salomon and Salomon. But there have been many critics. And these critics have been in courts, in decided cases, but also academic writers. The main reason for criticism was that there's a principle that was vague and undefined. And this decision by the South African Supreme Court in 1995 used language that summarized what many critics were saying, that it is not clear what are the circumstances in which it is permissible to pierce the corporate veil. And of course, this kind of doubt is of particular concern to commercial lawyers who are advising their clients about setting up structures, about going into transactions, because that is the point at which they would like to have some certainty as to what is likely to happen with the structures they advise. Other cases have gone further. In this Court of Appeal decision in New South Wales, the court said there's no unifying principle. There's no principled approach to be defined from the authorities. Canada Supreme Court made the same point. New Zealand went even further. Said it's not a principle at all. It's a process. That phrase is no guidance at all as to when it can be used. Because perhaps they are not bound by judicial reticence. Other academic writers were even more critical. And I just look at two quotations. Canadian Business Law Journal described the jurisprudence as incoherent and unprincipled. And the Chicago Law Review said piercing was like lightning, rare, severe, and unprincipled. And closer to home, then Professor Andrew Burgess made the same point in his book, Commonwealth Caribbean Company Law. The courts have not done this in a systematic way, and it's difficult to find any unifying principle. Not surprising, courts have had opportunities and sometimes tried to determine an applicable principle. This decision by the Bahamian Court of Appeal is an example, Canadian Imperial and Horn, where the president of the court said he would lift the veil where the company has been used as a cloak. So effectively, where there's a concealment of true ownership. While Justice Appeal Smith said, no, that's not enough. If a company is not incorporated for any legal purpose and used for something like fraud, then you shouldn't pierce the veil. So he'd have wanted a stricter standard for when you should do it. And the third judge said, well, we don't have to decide that today. So ended up, again, as in many other cases, with the principle continuing to be that it would be applied as the courts thought appropriate. But there was then a trend in the other direction. Courts have in more recent times, and I'm now in the late 90s, early 20s, declined invitations to either pierce a corporate veil or to treat a group of companies as a single economic unit. And an important case is the decision of the English Court of Appeal in Adams and Cape. It's a case that actually involved 205 consolidated claims. And the court delivered a judgment in which it reviewed the history of this matter, a great number of decisions. It dismissed on the facts of these cases both the single economic unit argument and the invitation to pierce a corporate veil. And there's an important guidance in the case that has been applied and adopted, approved in subsequent cases. They accepted that this could be done in appropriate cases, but it will be an exceptional situation where the veil could be pierced. What perhaps most important is Lord Justice Slade's observation that the court is not free to disregard Salomon and Salomon merely because it considers that justice so requires. And you recall the quotation from Lord Justice Cummings Bruce, which said exactly the opposite, that the court will do this when it is necessary to achieve justice. The same court in Adams said, you can't do it for that reason. Justice requiring it is not a sufficient basis to pierce the corporate veil. Of course, they didn't say what is a sufficient basis, but at least they said what is not. The trend back to Salomon took a big step in 2013, and whether this is a step forward or backward, of course, depends on your own perspective. The Supreme Court in England convened a special panel of 7 judges in order to address this issue. And it was obvious that this was done with a view to settling, defining what is the principle on which the courts will intervene and pierce the corporate veil. This was a matrimonial property dispute where Mr. and Mrs. Prest parted. The court awarded Mrs. Prest, I think it was £17.5 million against Mr. Prest. But he had no assets in the UK. He controlled a number of companies which did, and these include companies in St. Kitts and Nevis, Isle of Man, various companies. He was a Nigerian oil trader. And the issue is whether the court could order the companies to transfer their assets in the UK to Mrs. Prest to satisfy the judgment that she had obtained against him. The trial judge held that he was entitled to pierce the corporate veil, and he ordered the transfer. The Court of Appeal allowed the company's appeal. They said the court had no power to pierce the veil in these circumstances. And their main reason was that neither the corporate structure nor the ownership of the assets had taken place for any improper purpose. Mrs. Prest appealed to the Supreme Court, who unanimously allowed her appeal, the 7 judges. And they reinstated the order that the trial judge had made against the companies, directing them to transfer the properties in London to her. But interestingly, they agreed with the Court of Appeal that this was not an appropriate case for piercing the veil. They said Mr. Prest had treated the assets as his own, but that did not justify the court doing the same. They were still the company's assets, not his. Corporate structure had been created for tax avoidance and wealth protection. nothing to do with evading obligations. So this was not an appropriate case to pierce the corporate veil. They allowed the appeal on a different basis, that they were held on resulting trust. There was actually, on the facts, that was a justifiable finding, although it may seem odd. And they came to that finding on two bases. Some cases, the properties had been owned by Mr. Prest, and he transferred them to the company for a nominal consideration. In other cases, the companies bought the assets before they had been trading, and so had no assets of their own. And the court considered that must have meant that Mr. Prest provided the company with the funds to buy the properties. And so they said that in all those circumstances, the companies held the assets on trust for Mr. Prest, and so he was a beneficial owner, and the court could therefore make the order. But those issues were dealt with very briefly in the judgment. Most of the 6 judgments were spent analyzing the cases in which the court had purported to pierce the corporate veil and questioning the jurisprudential basis of the principle. The Supreme Court in Prest held that, as Lord Justice Slade had held in Adams, that it is rare that the court would or should pierce the corporate veil. They emphasize Salomon and Salomon, and most of the cases we've been discussing, Salomon and Salomon was not even mentioned. In all these cases where the court pierced the corporate veil because of justice, or to see the true realities, or because they wanted to see what is behind the veil, they just didn't mention Salomon. Prest reaffirmed it, stressed that any issues in relation to this doctrine must start with Salomon. And Lord Neuberger said, this is more than a century of this decision being in place, not being challenged, nobody questioning its correctness. We need to follow it. There needs to be some very good reason why you would depart from such a well-established principle. Lord Sumption delivered the main judgment, and he sought to define the principle and to explain the circumstances in which it may be appropriate to pierce the corporate veil. And he said it could only be pierced to prevent the abuse of the corporate legal personality. And he gave some examples of what would be an abuse and what would not. And he made a distinction, first of all, that it is not an abuse to avoid a liability, because there are limited liability companies. The whole purpose of limited liability is to make the liability that of the entity, the company, and not of the person controlling it. The real distinction, Lord Sumption said, was between what he called an evasion case and a concealment case. In an evasion case, where the controller was trying to evade a liability that was his, the court can place the corporate veil. But in a concealment case, where the controller is trying to conceal the ownership of the asset, or perhaps even the source of its acquisition, the court could not pierce the veil. Now, although the case was heard by this special panel in order to settle the issue, at the end of it, it still wasn't. Because although Lord Sumption has stated very clearly what he considered the issue to be, four of the 7 members of the court said there might be other occasions. It would be rare, but this distinction, evasion and concealment, was not necessarily the final word. And in Prest, they didn't overrule the many cases where the court had pierced the veil and where they ought not to have done it based on this concealment evasion distinction. And basically they said in those other cases, the result, they shouldn't have pierced the veil, but the end result was justifiable on another basis. Just as in their case here, where the trial judge was wrong to pierce the veil, but he was right to order the companies to transfer the assets for this other basis. They talked about Guilford and said the court should not have pierced the veil in Guilford. But what the court in Guilford could have meant when they said cloak or sham is that there's a principal-agent relationship. And if there's a principal-agent relationship between the company and its principal, it was appropriate in that case to make an order against the company. And they could well have justified. They didn't discuss the Privy Council decision in Crawford, but if they had, they could well have justified that on the same basis. So we have a decision here which does two things. It says very clearly, you should greatly limit the circumstances in which you pierce the veil. You need to go back to Salomon. You need to follow that bedrock principle. But they also said, here is a way, a principle to determine when to do it. But there are many other circumstances where you may get the same result, but you're not piercing the veil. The same year that Prest was decided, Jamaica's Court of Appeal decided International Hotels and Proprietors Strata Plan 461. And in fact, the case was heard before Prest, and while the judges reserved, Prest came down. And the issue in that case was whether a company could acquire property by adverse possession against its parent. So a wholly owned subsidiary occupied some property, and there are two adjoining properties, occupied some property owned by its parent company. They then came into separate ownership, the companies did, and the subsidiary under new ownership claimed that it acquired the parent's property by adverse possession. And there were a number of other issues in the case. The argument against that was you should pierce the corporate veil. You shouldn't treat these parent and wholly owned subsidiary as separate legal identities for a purpose such as acquiring property by adverse possession. And there was therefore no adverse possession in those circumstances. The Court of Appeal applied Prest. It said that Prest was a reaffirmation of the robustness of the principle of separate legal personality. And Justice of Appeal Morrison, as he then was, spent some time on Prest and what it was saying about our recognizing and going back to and staying with the principle that Solomon had established more than a century before, and that had never been really challenged. There was, it also, the Court of Appeal considered Lord Justice Slay's judgment in Adams, confirmed it, reported it, supported it, and said that there was no ground for going behind the corporate veil in this case. A subsidiary could and did acquire the parent's property by adverse possession. So we have two decisions here where in the UK and in Jamaica, where appellate courts have said we really should stop lifting the corporate veil in these multiple circumstances, and there are very limited cases where you should do so. But despite these decisions, the courts have continued to do so. And in fact, it might even be said that there has been an increasing number of cases in which this has been done. In England, there have been a number of cases where the courts have focused on what they have called practical realities. Again, that phrase that Lord Denning started about looking at the realities. And who, in determining who should be considered the true owner of the underlying assets, one should look at the specific facts of the case and, as I say, what they have called practical realities. And interestingly, they have even relied on Prest and on dicta in Prest in doing so. And in the same way that there was a century of nobody criticizing Solomon, but nonetheless finding ways around it, nobody has criticized Prest. In England in particular, and in many other Commonwealth countries, certainly throughout our region, the courts have recognized and accepted Prest as giving appropriate guidance. But then cases have relied on dicta from Prest to come to a contrary result. This JCA Bank and Ablayev case is one of a great number of judgments in long-running litigation between the bank and its former principal. Mr. Ablayev arranges affairs in companies in various jurisdictions, and one is a company in the British Virgin Islands, which owned a valuable flat in London. And this apartment, I think, was in the same area as one of Mr. Prest's. Mr. Ablayev was not the shareholder of record, which is not unusual in offshore jurisdictions like the BVI. The bank obtained a very substantial judgment in the UK against him, and they wanted to enforce a judgment against the flat. And of course, the issue was, how can you do so when the flat is owned by a company, which is a separate legal entity, and of which Mr. Ablayev is not even a shareholder? But the court held that the evidence was that the officers of the company, the persons in the BVI, acted on Mr. Ablayev's instructions. He was therefore to be treated as a beneficial owner of the shares, and the company, the claimant, could enforce the judgment against those shares on this evidence, that is, the instructions given and acted on. The court in Ablayev referred to Prest, but it quoted one passage from Prest. Whether assets legally vested in a company are beneficially owned by its controller is a highly fact-specific issue. And those of us who practice in the courts know that that is a phrase that one uses when one wants to get around precedent. A highly fact-specific issue turns on this case, the facts of this case, the evidence in this case, are not necessarily on precedent. And the court held that Prest made that observation, actually from Lord Thompson's judgment, that this was a observation that would apply generally. Our facts are highly fact-specific. It's appropriate in this case to treat the assets of the company as being owned by the defendant. And the English courts have done the same in a number of other cases. These are all actually just in the same year, 2014, where the courts not only effectively lifted the veil, but they quoted the same passage from Prest. This is a fact-specific issue. We think that on these facts, the shares are actually owned by the company. No reference to Salomon, no reference to actually piercing the veil. This is just a situation where one can find that the assets belong beneficially to a principal, or can be the subject of enforcement because of a claim against a principal. An interesting case, much more recently, from the Ontario Court of Appeal, Geddes and Chevron, took a slightly different tack, but is still relevant to our present issues. A group of indigenous people in Ecuador secured a very substantial judgment, and this is a US dollar number, against Chevron Corporation. And this is because of damage to the environment, because of the company's oil operations over an almost 30-year period. The thing, though, is that by 2011, when they obtained this judgment, Chevron Corporation no longer had assets in the region, and they had a difficulty in enforcing the judgment. They therefore sought to enforce the judgment first in New York against one set of subsidiaries, and then in Ontario against a particular company, Chevron Canada. Now, this is a 7th level subsidiary. So it is a subsidiary of a subsidiary, etc. Far removed from Chevron Corporation, but still a wholly owned 7th level subsidiary. They sought to enforce the judgment there, and Chevron Canada applied for summary judgment. And they applied the made the application on the basis that its shares, Chevron Canada shares, were not an asset of the parent company, and these were not circumstances where the plaintiffs could successfully move the court to lift the corporate veil. And the court agreed. The appellate court dismissed the plaintiff's appeal and held that this was not an appropriate case to pierce the veil. But they reaffirmed the position in Canada as to the circumstances where the court would pierce the corporate veil. And there are three circumstances, but the second one is the really important one for general purposes, which is when the court is satisfied that the company is a mere facade. Now, that phrase taken by itself appears very wide and appears to be similar to the language used by like the Privy Council in Donovan Crawford and many of the other cases where people just said, this is a sham and a facade or a mask, and we can look behind it. But the court went further and explained that mere facade required you to prove two things. One is complete control, such that the subsidiary is a mere puppet. And the other, perhaps more important, is the purpose for which the company was incorporated or used. And it needs to be something improper, so that for you to invoke the mere facade exception and move the court to pierce the veil, you need to go further than just control and show some kind of fraudulent or improper purpose. And needless to say, there's no suggestion here that it would be enough to say justice required it, or one can look for the real realities. You need to show an improper purpose. The thing, though, is that a dissenting judgment, dissenting on this point, by Justice Nordheimer, has actually gotten more attention. And Justice Nordheimer agreed with the ultimate result, which was that on these facts, the veil shouldn't be lifted. But he expressly disagreed with the limitation that the majority placed. He said the categories are not closed. The courts can lift the veil to do justice. Going back, you recognize to re-air company. Going back to this issue of there must be a residual power if the justice of the case requires it to lift the veil. And in a sense, this is not unlike what the other four judges said in Prest. You recall that the four judges said, yes, I agree with Lord Sumption's analysis, but I am not prepared to say that those are the only circumstances where the courts can lift the veil. There may be others. Effectively, that's what Nordheimer said. And as I say, that dissenting position has received a lot of attention, I think, both in Canada and certainly elsewhere where persons have looked at this decision. And it's also useful to note that as the courts did in Ablayazav and other cases, he looks to Prest. He said, here are dicta in Prest that support my exception, my saying that there is a residual power to lift the veil to do justice. Finally, in terms of decisions, I just mentioned two recent decisions by Jamaica Court of Appeal, which actually came to differing results, but treated with this issue in different ways. One is a case called the Euro Urban Development Corporation and Jassitar, and then there's Houston. Now, Jassitar involved a lease of a commercial warehouse. The Urban Development Corporation leased the warehouse to Jassitar, and there was a requirement that the UDC would provide security, but its subsidiary provided the security by contracting with an external company. There was a break-in, and the tenant, Jassitar, sued its landlord for breach of contract and negligence and succeeded at trial. But on UDC's appeal, the real issue, the primary issue, was whether the security guards who were plainly negligent were the servants or agents of the landlord, of the appellant. And that in turn depended, the court felt, on whether the court could pierce the corporate veil and treat the UDC and its subsidiary as one entity. Now, one can debate whether that second step was correct, whether the court actually had to pierce the corporate veil in order to uphold the judgment. But they treated that as the issue. Could the court pierce the corporate veil and treat them as one entity? And the Court of Appeal said no. There was no basis in these circumstances to treat them as a separate entity. And they said what courts have said in many of these cases. There are cases where it is appropriate to pierce the corporate veil, but they don't arise here. And I gave one example, which is cases of fraud. And generally, as was the case in Canada and elsewhere, courts and critics accept that fraud is an appropriate case. But having said this, that fraud is an example, the court didn't go on to say what are the cases, what are the other circumstances in which it could be done. And they made no mention of either Prest or International Hotels in coming to the conclusion they did. Sam, the year after, same court, is a perhaps easier case because the facts are so similar to Prest. As in the case in Prest and Petrodel, it was a matrimonial property claim. The home was owned by a company in which the husband was a sole shareholder. So the wife was not a shareholder in the company. The evidence was that the company had been formed for tax purposes. So there was no question of the company being formed for an improper purpose, and there was no question of the property being transferred to the company for an improper purpose. And the trial judge declined to pierce the corporate veil and held that the wife could not claim an interest in the property by reason of, given the circumstances of his ownership of the company's creation and the reasons why the property was so held. But the Court of Appeal allowed her appeal. And the court didn't mention International Hotels, but they mentioned and applied Prest. They did exactly the same thing that the Supreme Court did in Prest. They said the judge was right to not lift the corporate veil, but the company held the property and trust for Mr. Sam. In the same way the Supreme Court said Mr. Prest's companies held the properties and trust for him. Company was just his nominee, held the property and trust for him. She could claim an interest, and in fact, half of the shares of the company. Similar facts, similar argument, similar outcome as in Prest. And so, another one of these cases where the court said, yeah, you're right. We can't lift and shouldn't lift the corporate veil here, but the result that the claimant seeks could be the same, but for another reason. And, you know, it might be difficult to argue on the facts of many of these cases, like this one, but the circumstance, again, shows the wide range of situation in which the courts will end up with a result that seems contrary to principle and certainly contrary to what a purist would think should be achieved in following strict company law principle of separate legal identity. Now, where are we today? Prest is plainly the leading decision in most Commonwealth countries, and I think throughout our region, where I've not seen any regional court question its approach or its accuracy, and the sentiment, and we put it no higher than that, and views expressed in the case should certainly reduce the circumstances where the courts will disregard separate corporate personality. And here in Jamaica, the International Hotels decision, which is to the same effect, should also have that effect. So that piercing the corporate veil as a statement and as a finding is likely to happen in far fewer cases. And so these cases reaffirm this bedrock principle in Salomon and Salomon, separate legal identity. But the courts will achieve the same result on various bases, concluding that the company was an agent for the controlling shareholder, or as the court did in Prest itself and in Houston, that assets are being held in trust by the company for the controlling shareholder. And perhaps even more controversially, by concluding, well, not more controversially necessarily, by concluding, as Lord Sumption did, applying his test, that there's an abuse of the rule. And this may be a point for me to mention that Lord Sumption's core distinction between evasion and concealment cases is hardly mentioned. And the many cases that have applied or sought to circumvent Prest, there's hardly ever any mention of that distinction, of that approach. But then the more common approaches are just saying the cases are fact specific, or that we look at the realities. And so where we are today is that the journey continues.
Thank you, Mike. As usual, excellent. In the words of John Jeremy in the chat, brilliant as always. So we thank you so much, Mike. And yes, something new every time, and the journey continues. And I'm a purist, maybe conservative, and I like the idea of certainty. And I like the idea that Prest attempted to provide some certainty. And I like the idea of sticking with Salomon and having that separate legal entity doctrine in place. However, I recognize that it's not always that simple, but I would rather that the courts would look for another way in which to achieve the justice of the case rather than lift the veil unless there's fraud. But there you have it. But I hear you. We are on a journey. And it's interesting because also for us in the Commonwealth Caribbean, which is most of us on at this moment, may be curious to know or to figure out where our jurisprudence is going. But that said, I have a question for you, Mike, if you don't mind, from Candice Craig in Montego Bay. And since this is just a specific question on the International Hotels case, she says, in the Court of Appeal case where the court held a subsidiary company could claim adverse possession against the parent company, when the adverse possession commenced, was the ownership of both companies the same? Hope you're listening, Candice.
Yes, thanks, Susan, and hi, Candice. The parent company, so that the company who was in possession was a wholly owned subsidiary of the parent company at that time. So since you're in Montego Bay, Candice, I'll just let you know that the land in dispute is what is now the nude beach at Hedonism too. For those of us on the call who know where that is. So yeah, it was common ownership at the time, wholly owned subsidiary. And so it was a credible argument that a wholly owned subsidiary ought not to be allowed or treated as acquiring its parent's property by adverse possession, because the circumstances of the possession and the permission and so on would not be consistent, arguably, with adverse possession. But the case really reflected two separate things. What we've been talking about, which is separate corporate identity, but also the changes in the law of adverse possession and what constitutes it. So.
Thank you, Mike. I am going to look now if there are questions from any in the company law class or from the YouTube feed. You can, I'm not, my company law class, Stephen Nelson. Go ahead, Stephen.
Greetings, everybody. Can you hear me?
Hi, Stephen. Yes, we can.
All right. Good morning, Mr. Hylton. So my question is in relation to Prest and Petrodel. So even though it seemed to, reaffirm the Salomon doctrine and it was aimed at synthesizing the law, doesn't it still leave attorneys and persons engaged in corporate dealings on a whole in a similar conundrum as to before the case came out, in that it states that, all right, the Salomon principle is the law. However, it may be ignored in certain circumstances where piercing the veil is appropriate. And even so, the list of circumstances that are given, it isn't exhaustive. And so there's a level of difficulty in predicting what the court may do in your particular scenario. And of course, that presents a problem for attorneys who are supposed to give solid and sound counsel to their clients, and of course to litigants who are engaged in commercial dealings and want to know what exactly they should do in such a scenario.
Yes, and for law teachers who want to know what to tell their students. But you're right. You're right that the case didn't result in certainty that some people hoped it would. I wouldn't say that we're in the same position, because I think that the case would reduce the circumstances in which the veil would be lifted, because it was to some extent a free-for-all before, and they're saying you at least need to find a specific basis, perhaps in some other area of the law, such as trust and so on. So it's not a open and shut certain case, but it is at least a reduction in the circumstances. And I'll tell you, this is a debate that's been ongoing, of course, for decades, and which I've had with many people. And you commercial lawyers can be divided between those who practice in the courts and those who are transactional lawyers who advise the clients before the problems arise, when they're creating the structures. And the ones in the latter group, commercial lawyers, want certainty. They would prefer to have a situation where it is clear what, as you just said, what the outcome is likely to be on a structure that they're advising. While litigation lawyers very often prefer to have the courts be able to look at the particular facts of a case and frame a result that's appropriate to that case. Much less certainty, but some may say greater fairness. So there's that dispute unresolved.
Thank you, Mike. And thank you, Stephen, for that question. I'll take one more from the class, and then I'll hand over to Celia to take some from the YouTube feed. Gabrielle Chin. Hi, Gabrielle. I'm not hearing Gabrielle. I saw her hand up. Gabrielle?
Can you?
Hearing you now.
Okay, thank you. Good morning, Mr. Hylton. My question may be a bit hypothetical, especially considering precedent, of course, and not wanting to disrespect where we're coming from, while also appreciating the fact that we're in a unique position, given that we're in the space where we can create our own Caribbean jurisprudence. But do you think it would be clearer and more effective for the law, in a sense, to make the veil the exception as opposed to the rule?
What's up? I've been sending the questions.
Okay. That is certainly out of the box. So now we have the veil as a rule and questioning what are the exceptions. Now, your question would mean, of course, abandoning Salomon and Salomon altogether and saying the veil is the exception. We should generally be able to treat companies as not being separate entities unless except in an exceptional case. I don't think that would be a desirable way to go, because there are good reasons why separate legal entities for companies is a good idea and is necessary. A lot of commercial business is possible only because of that separate legal identity concept. And if you consider that it allows multiple ownership, it allows investment and fundraising from various sources, it allows a lot of commercial activity that would not be possible, I suspect, if in your hypothetical example, the veil was the exception rather than the rule. So as much as I am more on the side of the commercial lawyers who are not unhappy about these exceptions, I certainly won't go as far as to make them the rule.
Gabrielle, why you have to blow up everything that I taught you? Thank you for that question. Okay, I'm going to ask Celia. I see that there are a number of questions coming in on YouTube. So Celia, could you address those for us, please? Celia, I believe your mic is muted. Your mic is muted.
Right. Thank you, Suzanne. Mr. Hylton, here's a question from Patrick McDonald. The respect, he says, being accorded to the principle in Solomon is occurring when legislatures worldwide are compelling disclosure of beneficial ownership of companies, and he wants to know if we think it will last. Maybe I could just put a couple of more questions to you, Mr. Hylton, so before you start answering. There's a question from Lynette Sieberan, who is asking, what about transferring the shares in a company as matrimonial assets rather than lifting the veil?
Yes. Before you ask, those two are fairly substantial. So let me.
Okay, go ahead, Ben.
Let me try to address both. Hi, Patrick. I think that trend towards involving legislative and governmental intervention in reducing secrecy, increasing disclosure, increasing the requirement for identifying beneficial ownership is going to increase. It is part of, as you know, international money laundering and I suppose crime fighting generally efforts. Whether we think that it's gone too far or not, just as a practical reality, I think that is going to happen increasingly. And in a sense, it is, your question is certainly relevant to present circumstances, because in a sense, that trend also reduces the efficacy of corporate structures and separate legal personality. Because it not only does involve what you said, which is the requiring information and disclosure, it also in some cases allows action. And we haven't discussed that at all in this presentation. The cases where legislative provisions allow usually the state or revenue to have access to corporate or personal assets, as the case may be, contrary to the basic rule about separate personality. So to answer your question, I think that's going to continue. The next question, hi Lynette. The question was, could you remind me, Celia, about the transfer of assets?
Right, so what about transferring the shares in the company as matrimonial asset rather than lifting the veil?
Right. Well, so that's what happened in HUSAM. So in HUSAM, this is one of the distinctions between HUSAM and Prest. In Prest, the court ordered the companies to transfer the property to the wife. In Houston, the court ordered the shares to be transferred, half the shares to be transferred to the wife. Now, as to which the court will do, I think will depend on whether the companies have other assets or liabilities and the convenience or not of doing the transfer. But in either case, you still have the same problem. These are all going to be cases where the person who controls the company does not want to transfer either the shares or the property. And so for the court to order the transfer of the shares, there has to be some level of lifting of the veil. And I'm going to use that phrase broadly. Either you're going to hold that there's a trust, or there's an agency, or there's a lifting of the veil. But there's going to be a judicial intervention in the basic principle of separate legal identity. You're going to have a situation where the court concludes, although this is a separate company, and there's no fraud and there's no improper purpose, I should still intervene and say the assets or the shares belong to the claimant. So I think in either case, you still have the same hurdle to cross.
Mike, if you don't mind me jumping in on that, I'm so glad Lynette raised it, because I was thinking about the same thing. I remember Lord Sumption in his judgment speaking to the fact that, well, maybe they could order the shares, and to your point, to be transferred to the wife. But then he said there would be problems because many of the shares were bearer shares. And so we're back to now these other issues that I think Patrick was raising, where you're hiding, well, I shouldn't say hiding, but using the corporate form to not disclose the true ownership of the shares. How is that? So I think it's interesting that even Lord Sumption mentioned it and then pulled back, because he said, well, that would be too difficult. I think resulting trust was easier to do. I don't know if you agree, but I think so. And
I guess a further answer to, and to be fair, Lynette's point, I think, is also that there are cases where you're trying to get at let us say, the husband's assets, and his shares in the company is an asset. So you ought to be able to transfer those shares without getting into any issue of lifting the veil.
Hey.
There'll be various other issues, as in many of these cases we looked at, the shares are not actually his, or the shares themselves are subject to other either charges or interest or debts. So, yeah. Celia, you had another question.
Yes, there's a terminology question for you, Mike. Whether there is a difference between piercing the veil and lifting the veil, are they really used interchangeably? Is there a difference?
Okay. There was one decision I came across where the court said there are two different things, and piercing means one thing and lifting. I confess I wasn't persuaded about the logic of that distinction, and it's not a distinction that has been maintained through the cases. In the vast majority of cases, those two words are used interchangeably. Okay.
Faye Lopez Collymore is asking whether or not Prest has provided any certainty that it seems that the avoidance of the corporate form was not called lifting the veil, but it has the same objective that is achieved by piercing the veil. And also the point that there seems to be really less principle on which lawyers can advise their clients. Is there a clear direction as to, when the courts will use one of these avoidance techniques?
I think the answer is no. That there's no certainty, and there will be many cases where the result is even different on appeal than it was at trial. So even during the case, there's no certainty. I actually think that it is not the kind of circumstance where certainty is going to be achieved. I don't want to sound pessimistic for those who hope for certainty, but there is none now, and I doubt whether there will be. And there'll be another debate as to whether there should be, but there isn't.
Celia, I'm going to jump in with a class question, someone from the classroom. Khalil Butler, you had a question? If you can turn on your...
Hello, can you hear me?
mic.
Yes, hello, Khalil.
Yes, hear you now.
Good morning, Mr. Hilton. So my question, I understand that the notion that it may be appropriate to pierce the veil based on, that it may be inappropriate to pierce the veil based on considerations of justice appears to be a bone of contention among scholars. In your slides, we realize that piercing the veil, there's no guidance that can be used. It's not a principle, but it's rather a process. And as we know, the Canadian case Cosmopolis concerned an attempt by the plaintiffs to pierce the corporate veil in order to impose liability against the company's controlling mind, but rather to assert ownership interest in the company's damages assets for the purposes of recovering under the insurance policy. This was unsuccessful, and as a result, most Canadian courts refused to treat this case as a precedent of the ability to pierce the corporate veil simply because it would be in the interest of justice. Perhaps this suggests that a more narrow test is needed. So how do you think the courts could alter the test more narrowly moving forward? And should courts move towards a position where seeking justice is an integral component in lifting the veil?
Let me give you a cynical response. I actually think that in many cases, although the courts have not said so, their decision to lift the veil have been based on their feeling that this is what was needed to be done to achieve justice. The courts have, unless you're a judge like Denny, who was bold enough to say it, courts don't like to base their decision expressly on something as inherently vague as to achieve justice. So they avoid using that as the basis. But I think that's the underlying basis in many cases, and you try to find a more robust or acceptable. Now, to your question, I have not been able to find a definition or a basis that can both allow the flexibility that I think will be needed to deal with some cases, some circumstances, but at the same time, falling within some defined, fixed, certain legal construct. So, as to, I see the desirability of having that defined construct and that certainty, but I have my doubts about how possible it is. Now, I mean, one way to achieve certainty is to say, you will never lift the veil. Corporate assets will never be treated as anything but that, and there'll never be a way to claim against the company because of a default or weak by the principal. So that achieves certainty, but will allow for a lot of fraud. Next level, you could say the one exception is fraud. If you show fraud, then you can go behind the veil, otherwise you can't. But I think many people will say that's too strict. Next level, maybe the position that the Ontario courts have said, which is fraud, improper activity. And improper activity can be a little vague, but still requires at least some proof of impropriety. But you then get a case like, amalgamated. This is a case with a guarantee by the parent company to the bank and the subsidiary made a loan. None of these exceptions we discussed would cover that. Is that the kind of case where the court should say the guarantee should be enforced, that it would not be right to allow the guaranteeing company to avoid liability when its subsidiary at its request did get the loan and didn't pay? So, there are various constructs that you could find that could give certainty. And the question is, do you really want that level of certainty with the necessary result that you're going to exclude cases from consideration when perhaps they ought to be considered?
Thanks, Kelly, for that question.
And there's another question here from Paola R. Scott, and who wants to know how would government companies stand up in an action against the government, which is the majority shareholder?
Yeah. So that has arisen from time to time. And in my former life, because of the increase, and I think this is true not just in Jamaica, but in cases, you have two public sectors. You have central government, and you have a whole range of entities which are controlled by government, which are not such corporations, are not such central governments, are really private, limited companies, but the government is the majority shareholder. And if a company like that incurs a liability, let us say, and cannot meet it, is insolvent, or can one look to the government? So I'm not aware of any case where in that kind of circumstance, there's been a lifting and there's been a court ruling that you can either get to the government because of a liability of a government-owned company, or vice versa, that you can get the assets of the company because of a breach or a liability by central government. In theory, you should be able to do so. The principles that we've been discussing in relation to private companies, the principles should be no different in government, but I haven't seen it from.
Do we have time for another question, Suzanne?
Well, I'll just jump to a couple students, and then you can go back to the YouTube.
Okay.
So I will take Rashida Plummer. By the way, Mr. Hylton, we have students from all over the Caribbean asking questions, and even from Canada. So it's quite interesting. So Rashida, you had a question.
Good afternoon.
Good afternoon, Rashida.
So my question was whether it would be appropriate if for the government to implement a legislation in where they set out cases where lifting of the veil would be appropriate, or should they leave it up to the courts?
My answer would be no. For two reasons. One, I don't like government intervention in commercial activity, and I would prefer to have participants in the industry and the court by way of their intervention to find these issues. But more fundamentally, come back to the question of what would that legislation say? How do you define it in a way that is the circumstance? Because you see, if you list 10 cases, 10 situations where we will lift the veil in these 10 and in no other, it will probably take a week for an 11th situation to arise where one can credibly argue we really ought to lift it here. So it's difficult for legislative intervention to resolve it. And again, it goes back to the previous answer. It can be done. It could achieve some level of certainty. Although, you would still have a debate about what it is. But I don't know that is desirable.
With all due respect, Mike, I like Rashida's suggestion. And I would put A, B, C, D, any other appropriate, not freakish situation.
But then that last one would open the door to the discussion.
Like moments. Okay, I'll take another student, and then we could take one more from YouTube, Celia, and
sure.
Then we'll have to. Time is upon us, so let me see whose hand is.
I think Stephen has his hand up. Suzanne.
Stephen, thank you, Stephen. Go ahead.
I'm going to start my video. Good Good afternoon or good morning, everyone, and good morning, Mr. Hylton.
Morning, Steve.
My question is: so we've seen in the cases that there are other instances in which the court can sort of achieve the same result as with lifting the veil, like agency, trust principles. But my question is, do you think that it would be in the interests of justice, for lack of a better word, I suppose, for the situations in which the veil can be lifted to be expanded, or for it to be restricted, and let's say we'll have other situations like with agency and trust principles to cover instances in which the veil is not lifted? So do you think that those other exceptions to the separate legal personality of a company are enough to, say, restrict the principle of lifting the veil to just fraud, for instance?
Well, so your original question, do I think it would be the interest of justice to extend or to limit the circumstances? No, I think strictly speaking, the interests of justice are best served by each litigant having his day in court. So by each case being determined in its merits. The interest of certainty, which is very important, not just the litigant in court today, but to the many who would like to stay out of court, who would like to plan their business. The interest of certainty is not served by the case-by-case approach. So depending on which one you want to achieve, the answer will be different. What do I think? I don't think that that it is desirable for the circumstances in which the veil is lifted to be increased. Because the more circumstances and the less defined these circumstances are, the less certain the situation will be, and the more difficult it will be for people to plan their business and for people to give advice and for teachers to plan their curriculum. But having said that, I am reluctant to close the door and to close categories and say there can be no more.
Thank you, Stephen.
So, Susan, there's a question from Theo, and maybe this could be the last question from the YouTube chat, but I'm going to ask you, Suzanne, if you could just indulge me if I could put a question to Mike for my own part. So Theo has mentioned, has noted, Mr. Hylton, that you mentioned the Chevron case, and he's saying that by the time the case was heard on behalf of the indigenous peoples, that the company, of course, had no assets left in that jurisdiction. And the question he wants to have you comment on is, does lifting the corporate veil help with remedying human rights breaches in this kind of scenario?
Yes. So I think in Susan's opening, she mentioned that the various cases that have considered this issue include human rights cases. Now, this is a particular wide-ranging area. I think, as you know, the Commonwealth approach has to human rights and the constitutional rights has largely been to give as much latitude as possible and to interpret the rights broadly. And I think, as you know, to courts have held that constitutions are living things and the rights change and so on. All of that is, and that approach is inconsistent with a strict defined limit. And so if, and that Ecuadorian indigenous people case, perhaps an example of the challenge that you face. If on the one hand, the court wants to recognize and uphold and meaning to human rights, while at the same time strictly recognizing separate corporate identity and principles like Salomon and Salomon. That's a tension that, you know, is going to, one is likely to suffer. Generally speaking, it's not been an issue because there have been not that many cases where that tension arises. But when it does arise, courts need to make a decision. I suspect that where it fully arises, most courts are going to be reluctant to depart from the strict company law position, because departing from it because of a desire to recognize and enhance human rights, you can't fit it into one of the other specific categories like a trust or so on, is going to might be considered a breach, a door that would be open so wide that so much can come through.
Celia, I know you have a burning question, and I would like you to ask it, but I have to indulge just one other student, and then you will conclude with your question. Thank you. Verona Dawkins. And do you have your mic on, Verona? Verona, your mic is off.
Good morning, Mr. Hylton.
Morning, Verona.
Yes, morning, everybody. I'm going back to the point. I know you've made the point many times, but as a law student, I'm interested in certainty because I get comfort in it. So I'm going back to the issue of legal certainty. And so I heard your comments as it relates to how do you arrive at a position, how do you maintain a position where the circumstances might be so different, and how do you serve justice? But if you were to look in the crystal ball a little and look down the road, I don't know if you do have a crystal ball, is there any way to provide that level of consideration, or is there a path on which we can see ourselves going where we find that the issue of the seesaw decisions might not come back in the near future?
Well, I don't have a crystal ball. And B, I have given a lot of thought. So both where we're going, where this journey is going to take us next, and so perhaps where we should go. Now, a lot of what has happened in the courts has been driven by who are the people at the top, who are the people who make up in our case, the UK Supreme Court Privy Council. And this could be a whole different discussion, but we've just had a decade of what I call the Newburgh Assumption Court, which was very different in approach and much less judicial activism than the previous decade of what one could call the Hoffman-Stein State Court. The judges who decided Prest and many other very significant cases during that decade have all retired. Now, I have some views. There's not enough material on the judges who now make up the court to make a judgment on where they are likely to go. And in relation to the CCJ, we know that we've not really discussed because there's not that much jurisprudence in this issue. While one might have an idea of how some of their judges would rule in previous here too, we don't have enough material. So to answer your question, it's very difficult to tell what direction we'll go from here. But my guess is that there's going to be more lifting of the veil and not less. Wow.
Thank you. Thanks for that question, Verona. Celia, your mic.
Sure.
Yes.
So Mike, given the way, how some companies operate by way of groups of companies, what you have referred to in your presentation as the practical realities of company life, isn't there a growing case for a defined, principled legal policy in the Commonwealth Caribbean about how to treat with insolvency in corporate groups in terms of the treatment of assets across the group for the benefit of the creditors, and about, of course, how to treat with intra-group loans? Or are you kind of satisfied that we will just continue to rely on agency, trust, and abuse of the corporate form to satisfy these insolvency issues when they arise.
So Celia, you keep a question like that for last.
For your sake, Mike.
Okay. The way in which corporate assets are treated in insolvency is, of course, a very important point, and there is. It is not a satisfactory situation, and it is not a situation where we ought to rely on, to answer your question directly, on trust issues and so on. Part of the difficulty with insolvency and winding ups is evidential. A lot of these cases we're talking about turn on evidence of what is done and what is planned to be done and so on. In insolvent situations, there's a lot of history. There's often a deficit of current evidence. It's much more difficult to litigate kind of issue. And the desire for certainty is greater in an insolvent situation because there are losses to be suffered and there's going to be an issue of who is going to take the loss. And so, again, a greater need for certainty. There is in this area greater legislative intervention, which I'd answered someone earlier to say that legislative intervention is not something I welcome, but in the area of insolvency, I recognize it as being a more desirable situation. But having said that, it's still not going to solve the problem. I mean, keep in mind that the very first case that started this whole discussion, Salomon, was an insolvency case. So, and so were many of the other cases we discussed. So it's still going to take you back to, in some cases, this issue of judicial intervention. Again, there's a better case for attempting to get certain through legislation in insolvency situations, but even there, I am not optimistic that will happen.
Thanks. Over to you, Suzanne.
Thank you, Celia. And in fact, it's, having raised that question and Mike having answered it in the way he did, it brought to mind what my company law lecturer some 33 years ago, Andrew Burgess, had said about the Salomon case, that if it is any case that they should have lifted the veil, it should have been that one. At an insolvency case where he thought it was unfair. So at the time, I don't put words in his mouth now as an esteemed judge of the CCJ. But thank you so much, Mike. You have gone well beyond anything we could have asked or imagined. And we are so grateful that you've taken out your precious time to share with us this morning, to answer the questions. I thank all of those who have joined on YouTube. I thank my class. I thank the class at St. Augustine and John Jeremy for allowing his class to join in. And I have to thank the technical team, Andrew Hutchinson, Ishmael, Mona Media. We are very grateful for all your efforts in making this a success. I thank the Deputy Dean for Graduate Studies, Tracy Robinson, for her tireless work in ensuring that we lift the level of discourse in the faculty and providing opportunities for that. And thank you for the graduate students for also joining. Thanks again, Mike. See you next year on the same topic with new cases. And I'm being presumptuous, but thank you so very much. It's been really quite inspiring. And I think we're now out of time. So thanks again. And if I've forgotten anyone, my apologies. Thank you for the students who posed the questions as well. Take care. I think we'll sign off here.